Hi, thanks for joining us and welcome to this session on indemnities. My name is Mike Cuthbertson and I'm joined by my colleague Anita Sevapalam. Anita and I are senior associates in the commercial IP and technology team at Travers Smith, and as such we often advise clients about indemnity clauses in the commercial contracts which we draft or review for them. This session is planned to take about 45 minutes, and the aim in that time is to explain what an indemnity clause is and some of the perceived and actual benefits associated with them. Why they can be useful, how to get them right if you do decide that you should include one in your contract, and how worried to be and how to limit that worry if you're required to give an indemnity. Indemnities are often slightly misunderstood, and they're often seen as a massive commercial point when, frankly, sometimes they really shouldn't be. Used in the right way, though, indemnities can be very valuable as a way of addressing identified risks in a contract. We'll also talk you through a few practical tips on how to make sure you're achieving what you intend. So let's have a look at the example on the slide. You often see this kind of wording in contracts, but what does it mean? And does the mere use of the word indemnifies actually add anything? So the example on the slide says, X hereby indemnifies Y for all losses that Y suffers as a result of a breach by X of its obligations under this contract. So the bulk of the session is going to focus on the function of an indemnity clause and some of the real and perceived advantages of an indemnity claim over a simple breach of contract claim. We'll also look at some drafting hints and tips. But first, I'll hand over to Anita to talk through what an indemnity is.
Mike's question in the context of the example on the previous slide is a bit of a trick question, and hopefully by the end of this webinar, the reasons for this will become clear. Indemnities, when drafted properly, are used to address specific known risks which should not fall to the responsibility of the indemnified party, and as such are made of two key components: a promise to reimburse the claimant in respect of a specific loss suffered, and an identifiable trigger, either a particular breach of contract or an external event that can either be in or out of the indemnitor's control. Now, it is widely believed that claiming under an indemnity will allow for pound recovery for a specific loss, and therefore many believe that the extent of what is payable under an indemnity claim is potentially greater than what you can recover by way of a mere claim for damages for breach of contract. Now, to understand this better, we first need to have a bit of a recap on what you can recover in a claim for damages for a breach of contract. Now, those of you who went to law school will remember that the rule is set out in the well-known case of Hadley and Baxendale, which established the remoteness test used to determine the types of loss that are recoverable. As a result of that case, a loss will only be recoverable if it was in the contemplation of the parties. Now, what is in the contemplation of the parties can be divided into two limbs. First, direct losses, which are losses which are in the natural result of the breach and are foreseeable because they are or ought to have been contemplated by the parties as being in the ordinary course of things. The second is indirect or consequential losses, which flow from the actual knowledge of the parties of special circumstances which were outside of the ordinary course of things. Now, to put this into context, let's take an example. If a company orders a shipment of noise-cancelling headphones so that its employees can work from home without constant interruption by the dog, partner, kids, noisy neighbours, insert noise here, then those headphones don't work, the company should be entitled to claim a refund of the price from the seller or a replacement pair of headphones that do work. The buyer's loss here is the purchase price because the goods don't work, and now that's very clearly a direct loss. If, on the other hand, the company's employees were less productive as a result of the continued interruptions, which the headphones might have avoided, that is unlikely to be viewed as a natural result of the breach, and the seller would quite rightly argue that any resulting losses for the customer are indirect. Now, when claiming for damages for breach of contract, as well as only being able to claim losses which fall inside these two limbs, you have to be able to prove there was a breach, and that there is a causal link between the breach and the direct or indirect loss you have suffered. And that's not all. Damages claims are also subject to mitigation, meaning that the claiming party has a duty to mitigate their losses as much as possible. And to top it all off, the paying party's liability may be subject to a cap, or they might have agreed exclusions of liability in the contract for certain types of loss, which would usually be indirect losses. And all of that is assuming that the cap is enforceable. Now, parties often use indemnities because they think that by doing so, they will avoid all of these problems and achieve the sought-after pound-for-pound recovery, but we'll be exploring the extent to which there is any truth in that belief.
So, why have an indemnity? As Anita says, is it really the case that it brings all these wonderful benefits that we've been talking about? What do indemnities actually do, and when is it appropriate to use them? So, firstly, and perhaps obviously, an indemnity is a good way of making clear the allocation of liabilities between contracting parties and the types of loss for which the indemnifying party would expect to be liable if you can't contract around those liabilities. So you very often see indemnities in relation to actions by third parties, for example. So that might involve regulatory actions, such as a fine imposed on an indemnified party by a data protection authority as a result of a breach of contract or breach of data protection law by the indemnifying party. You might also see an indemnity in respect of a claim made by a third party alleging IP infringement, so that the indemnified party's use of the indemnifying party's IP rights infringe a third party's own intellectual property rights. And sometimes you also see it applying where there's a liability that comes about by operation of law, and the classic example of that is the application of TUPE to the transfer of employees on commencement or termination of an outsourcing agreement. So let's have a think about this in action. So the next slide, there's a scenario and some example wording, and that's based on a contract for the supply of smart meters, in this example by a meter manufacturer to an energy supplier. So in the scenario, an energy supplier in the UK has 1 million domestic customers, and the government requires the energy supplier to ensure that each of those customers has a smart gas meter and a smart electricity meter installed in their homes by June 2025. And if they fail to hit that deadline, the energy supplier is likely to be fined by Ofgem. And at the moment, no one yet knows quite what those fines are going to look like, the circumstances in which they'd be levied, or how much they're likely to cost. So energy supplier enters into a contract with the meter manufacturer for the supply of the meters. The manufacturer, in this example, defaults on its obligation to supply, and the deadline is missed. So the contract between the supplier, that is the manufacturer, and the customer, the energy supplier, includes the following indemnity. The supplier hereby agrees to indemnify the customer from and against any fines and penalties levied by a competent authority, which in this case would include Ofgem, and any associated loss, costs, claims, damages, or expenses suffered or incurred by the customer as a result of a breach by the supplier of its obligations to deliver the volume of meters ordered by the customer during the term. We'll come back to that example and variations on it a couple of times in the session, but for now it's just worth noting how specific it is. It's targeted squarely at fines levied on the indemnifying party as a result of a breach of contract by the indemnifying party, and refers specifically to the breach that it's talking about and the potential losses. So the first thing in terms of the advantages of having a clause of that type is that it suggests that both parties contemplated that a causal link might exist between non-delivery by the supplier and the customer being handed a fine by Ofgem. So that's worth having. Secondly, there is something there about direct loss. Assuming the causal link can be established, the supplier is unlikely to succeed with an argument that the fine or penalty is indirect loss, even if there's a general exclusion of indirect or consequential losses in the contract. That is unlikely to get them off the hook here. By highlighting the specific risk and making provision for it, the parties can sidestep arguments altogether about whether or not the loss was within the contemplation of the parties and which limb of Hadley and Baxendale it should fall within. Clearly, the parties have thought about it and they're dealing with it through an indemnity. In fact, there's some merit, I think a lot of people think, in not referring at all to direct or indirect loss in indemnity wording to avoid implying some sort of remoteness test that isn't appropriate. Anita will come back later to what happens if this is deemed to be a claim for debt rather than for damages, because the point position on directness and indirectness and remoteness is less relevant there. And then, while it's clear that the fine is a direct loss, I think it's fair to say that an indemnifying party might have more luck with arguments about the slightly vaguer element of it, the concept of associated costs. And both parties actually might want to be more specific about what that's intended to cover. For example, reputational damages, penalties for late payment of the fine itself. So we can come back to that when we get to some drafting tips in a sec. And the other advantages I would just point out is the benefit of having certainty in these circumstances. If the parties can allocate and share risks in this way, they can plan for the worst case scenario and they can also insure appropriately. The most extreme example of this is what's known as a knock-for-knock arrangement that's very common in building industry and oil and gas contracts in particular. And in that situation, each party indemnifies the other for any loss arising in connection with the indemnifying party's own property or personnel, and that's pretty much regardless of who's at fault. Again, the idea there just being to create as much certainty around who's responsible for what loss. And then I think on the other hand, it's important to just point to a few caveats. It's not all rosy, and the indemnity doesn't necessarily get you to where you want to get to just by including the word indemnity in a contract. So there are a few things to look out for when using indemnities to apportion liabilities in this way. Firstly, it's possible that if the effect of an indemnity is to exclude the indemnified party's liability for matters for which it would ordinarily be liable, it's possible that it could be construed as an exemption clause and therefore unenforceable. That's particularly the case in B2C contracts, so the Consumer Rights Act might apply. Less common, although still possible, in a B2B context, if it's found to be unreasonable under UCTA. One sort of mini drafting tip on that is that you might want to think about drafting the indemnified losses as a series of sub-clauses to try and persuade a court to sever the offending parts and leave the rest of it untouched. Secondly, the court will generally require clear wording to the effect that any deliberate or negligent acts of the indemnified party are intended to be covered by the indemnity. Although it's perfectly possible to do that, you just need to show the court that that's what you intended. It's generally not possible to be indemnified for civil or criminal penalties arising from the indemnified party's own intentional and knowing acts for public policy reasons. For example, if the indemnified matter amounts to a breach of competition law, for example. And then finally, the usual restrictions apply if an indemnity is triggered by a breach of contract in terms of penalties, and it mustn't be extravagant or unconscionable, the amount that's seeking to be recovered. That's unlikely to be an issue in most circumstances with an indemnity, because an indemnity generally just allows the indemnified party to recover the amounts that it's paid out. So just moving on to the next slide, I'm going to quickly run through a few specific suggestions for drafting to cover those points. So on the causal link, just this idea that we want to set up a very clear connection between the breach and the indemnity, or the trigger event and the indemnity. That's often implied within the contract, but if you want to really ram it home, you could consider including words to the effect that the parties acknowledge and agree that, something of that sort, either in the clause itself or perhaps in a recital if it's sufficiently important at the beginning of the document, just to set up the expectation. Secondly, on the point about remoteness, it's worth stipulating that the indemnity only covers instances of loss arising as a direct result. So that's if you're acting for the indemnifying party. So that would help the indemnifying party resist an argument, for example, that the indemnity covers, as I said before, reputational harm or late payment penalties, clearly less in the interests of the indemnified party, because they want it to be as broad as possible. Because if you are acting for the indemnified party, it's better to avoid using that sort of terminology, because that suggests that the parties intend to use a sort of Hadley-Baxendale type test for establishing the type of loss that the indemnity is meant to cover. And in that case, it's more helpful to the indemnified party to use causative wording, like such as arising out of or in connection with, and will help to sidestep the issue of remoteness. It's also better if you're the indemnified party to expressly carve the indemnity out from any overall cap on liability or any exclusion of liability for certain types of indirect or consequential loss. And again, the indemnifying party would obviously want to resist any attempt to do that. Then just a quick word on the clear wording I mentioned before. As I say, if the indemnity is intended to cover the indemnified party's deliberate or negligent acts, you need to say so. But that can be as simple as something along the lines of regardless of whether such loss arises as a result of the breach of this agreement or deliberate or negligent act by the indemnified party. And then finally, just a sort of broader point, you just need to consider whether any third parties will need the right to enforce the indemnity. And again, classic example is a cheapy indemnity, which might need to be enforced by a successor provider of the services. So I'll hand back to Anita to talk about the ease and the extent of recovery under indemnities.
So the basic principle around recovery under indemnities is shown on the slide. So the indemnifying party must pay on demand, thus avoiding the need for the indemnified party to bring court proceedings to recover its loss. However, this advantage is often more theoretical than real because the indemnifying party may either dispute whether the loss being claimed is actually covered by the indemnity in the first place, in which case the indemnified party would have to bring proceedings to enforce the indemnity, or they may argue that the amount being claimed is based on too broad of an interpretation of the clause. Now, in cases where a particular breach of contract can lead to continuing losses, taking an indemnity against that breach can improve the recovery of later losses. So say, for example, a company suffers a large, embarrassing public data breach, and a claim for damages for breach of the relevant data protection obligations would mean that the clock on the limitation period starts running. Now, an damages claim involves an assessment of past and future losses. However, if the size of the breach is so large that it takes time to figure out the end data subjects that are affected and the extent to which they are affected, pursuing a damages claim would mean that the court would have to take their best guess as to what the loss would look like. So even if in 2 years' time further losses are identified that would exceed the amount that was awarded for the damages claim, tough. You'll not be able to make a new claim unless there is a new breach or the breach is found to be continuing. If you claimed under an indemnity for the same breach, you can draft the indemnity to allow you to claim for future losses, i.e. each new loss arising out of the same breach would give rise to a new duty to pay. Now, whenever a new loss occurs in this scenario, a new indemnity claim arises and the time starts running against it. And if the first indemnity claim becomes time barred, that will not affect the later claims. You may also have a fresh breach if the indemnifying party refuses to comply with its obligation under indemnity, but that is more of a side note for information. Now, moving on to understand how to achieve these benefits, there are 2 key elements to include in your indemnity. First of all, you need to state that the indemnity is payable on demand. Now, those 2 words, although small, will avoid the hassle of going through the court proceedings, and in some instances, you may have cause to delay the start of the limitation period. So if no claim for payment arises until a demand is made, this will give you more time to sue. You should also include the words "and keep indemnified," both of which are highlighted on the slide. The general consensus seems to be that including this wording sets the intention to be able to recover for later claims under the same indemnity in respect of the same breach. Now, note that it might not be appropriate to include this wording in certain clauses where the underlying obligation relates to a one-time only event, such as compliance with data protection laws versus the supply of goods. Now, once the parties are in agreement that the loss is in the scope of the indemnity, how much can you actually recover? It's a common belief that indemnities allow for a potentially higher recovery and is often a pound-for-pound recovery of the loss suffered, as we explored and set out earlier. But however, not every indemnity gives 100% of recovery for all loss caused by the trigger. In actual fact, the extent of the recovery will turn on whether the indemnity is treated as a debt claim or a damages claim. Now, the quote on the slide is by Lord Justice Staunton in the case of Total Transport Corporation versus Arcadia Petroleum Limited, and it illustrates the distinction between these 2 types of claims. The first part of the statement is saying that the word indemnity is used in 2 senses. The first, it may mean simply damages awarded for tort or breach of contract. Now, this is clearly pointing to a damages claim. And the second part of the statement goes on to say, alternatively, the word indemnity may refer to all loss suffered which is attributable to a specified cause, whether or not it was in the reasonable contemplation of the parties. Now, that is pointing to a debt claim. So let's break this down a little bit further. A key distinction between a compensation under a debt claim and a damages claim is therefore that a debt is a definite sum of money that is determined by contract and ascertainable at the time the payment is due, whereas an award for damages is assessed by the court as a best guess to account for past and future losses. There are a number of advantages if the indemnity is treated as a debt claim. So firstly, the indemnified party may be able to recover more from party A than it would have ordinarily been possible if it had brought a claim for damages through the courts, even though it relates to the same loss. As we said earlier, there is also no requirement to mitigate your losses. And lastly, the rules on remoteness don't apply. So as a result, the indemnified party is more certain to recover its actual losses, and it means that there is a potential for a more significant sum to be claimed, as the amounts covered do not need to have been within the reasonable contemplation of the parties, even if that person could have taken reasonable steps to mitigate its loss. Whilst all of this sounds great, whether an indemnity will be treated as a debt claim will actually turn on the drafting, as is often the case with contracts. So here, if you're in the indemnified party, the more specific the indemnity is, both in terms of the parameters for establishing the amount to be paid and the specificity of the scope of the losses covered by the indemnity, the more likely it is that it will be construed as a debt claim rather than a general damages claim. But don't be too quick to assume that you're in the clear if the indemnity is drafted and treated as a debt claim, because even if this is the case, the advantages can be negated by the paying party through yet more clever drafting. So if you are the indemnifying party, you'll want to amend the drafting so that the clause specifies that the indemnified party is under a duty to mitigate its loss. And whilst there's no duty to mitigate under common law, the parties are free to change this position under the contract, remember, so that's why this is an important point to keep in mind. And similarly, you can amend the drafting so that your liability under the indemnity is reduced, either by bringing it under the limitation of liability clause, or reducing your exposure by requiring the loss to be within the reasonable contemplation of the parties, therefore introducing a sort of Hadley and Baxendale test, and requiring the loss to be reasonably and properly incurred. Another way is to limit payments to third-party claims brought by specified third parties only. And this way, for example, claims for loss management time of the indemnified party can be outside the scope of the indemnity, as is liability for individuals or roles that are not named. For example, you could limit it to just the contracting party only and not employees, agents, and subcontractors. You can also insert conduct of claim wording. Now, if for example, if the indemnity is intended to cover claims made by third parties, it would be appropriate to include conduct of claims clause, which would oblige the indemnified party to firstly notify the indemnifying party of the claim, not prejudice the settlement of the claim, and hand control or conduct of the claim to the indemnifying party. Now, this is particularly important to consider, including in consumer-facing contexts, as your name or brand will be at stake. So therefore, the benefits of categorizing the indemnity as a debt claim are often lost to the indemnifying party, and the analysis becomes more theoretical. Let's take a look at some practical issues then. So do you need to actually fix the amount that you want to claim? Here, the first thing to note is that an indemnity can be valid without specifying in any detail the payment due or the method for fixing it, but a promise to pay a specified sum would clearly be more straightforward than a requirement to pay all losses. Some contracts address this process of assessment and proof by providing a simple mechanism for calculating the amount payable. As a matter of normal business practice, the indemnifying party will probably want to see evidence supporting the indemnity claim to convince that payment is due under the contract terms. The evidence should show that the trigger event has happened and how much loss that has caused. To avoid this burden of proof issue, the indemnified party can include certification of loss wording, whereby the parties agree that the indemnified party's statement of the amount due will bind both parties, or that it will do so except for manifest error, thereby introducing an element of certainty around the calculation. You could also expressly require payment without any contractual mechanism for the claims to be substantiated, although the indemnitor can claim a refund in instances where the underlying claim was unjustified on the grounds of unjust enrichment. Next, let's take a look at the issue of when payment is due. Now, it's best for the indemnified party to ensure the indemnity is payable on demand, as we've covered earlier, as it helps to bring clarity as to when the payment is actually due. So you can be clear on the amount to be paid and when it should be paid, but how do you address the likelihood of payment? So like any other contractual promise, the value of an indemnity depends in part on the supplier's financial strength. And if a supplier is struggling financially or goes bust, its indemnity will be worthless. So it's therefore worth requiring the indemnity to be backed by insurance, as Mike has alluded to earlier, so that the indemnity or any promise could be more valuable. So here you would be able to specify the minimum level of insurance cover and the type of insurance. And it would be even better if the indemnified party could be named on the policy. If, despite your very clear drafting, the indemnified party still refuses to pay, what do you do? Now, here you'll need to follow the dispute resolution provisions in the contract. So it's therefore important to ensure that it is workable in practice and it has appropriate escalations. Alternatively, you could provide that any dispute over the quantum of loss to be claimed under the indemnity should be dealt with by expert determination. Now I'm going to move on to Mike to take you through hold harmless wording.
Yes, so thanks, Lita. We just wanted to take a quick look because often, because indemnities are so heavily negotiated and so hard fought over and I think quite an emotive issue in some ways, they often tend to go on for long periods of time and pages and pages worth of text, some of which appears to not mean very much. So having looked at what an indemnity is and limitations and some drafting tips, we want to talk briefly about the phrase hold harmless, which is a phrase you see in indemnities quite a lot, but one that lots of people overlook or misunderstand. So, for example, if we go back to the smart meter manufacturer we talked about earlier, that indemnity clause could be modified as shown on the slide. So, supplier hereby agrees to indemnify and hold harmless the customer for fines and penalties levied by a competent authority, and so on. So, the leading English case on the meaning of hold harmless is a case called Farstad and Viraco. And in that case, the Supreme Court held that in some contexts, hold harmless and indemnify effectively have the same meaning. But in the context of the particular clause in that dispute, the phrase went beyond the obligation merely to reimburse the indemnified party. It also meant that the indemnifying party renounced any right to claim damages from the indemnified party in connection with the same issue. So, for example, for any breach that the indemnified party which might have contributed to the loss. So, in an abstract sense, the word indemnify generally grants rights to the indemnified party, i.e. the right to receive an amount of money on the occurrence of a defined trigger. On the other hand, the phrase hold harmless generally limits the indemnified party's liability. In more concrete terms, the meter supplier might not be entitled to counterclaim against its customer if the customer has contributed to the shortfall in deliveries by refusing to accept those deliveries as required by the contract. I think a couple of caveats just to finish on things to be aware of when you're acting for the indemnified party in particular. Farstad suggests it might not actually achieve anything more than the indemnity. So if there wouldn't be a basis for the counterclaim in any case, consider whether it's absolutely necessary, whether it's worth having that wording in at all, or in fact whether you can accept it by the same token because you think actually it's very low risk. And then, as we previously mentioned, exemptions can be unenforceable if they are seen to be too broad. And that might be the case if the energy supplier has actually been refusing to accept deliveries. For example, a court might be unimpressed with that kind of behaviour and not be willing to hold it to the strict meaning of hold harmless. And then a couple of drafting tips if you're acting for the indemnifying party. I think we'd suggest that you try to avoid the hold harmless language at all, unless it comes up in a mutual context, and that's very often the case, as we mentioned before, in these sort of not-for-not contexts. You often see each party holding the other harmless. You might provide the party being held harmless won't be entitled to recover to the extent that losses are caused by its own fault or negligence. So that goes back rather to something Anita was saying earlier about you can sort of undo some of the damage, as it were, done by the drafting by some other drafting. And then you could also specifically reserve the right to counterclaim. And again, I think it's fair to say that lots of people, frankly, won't know what hold harmless means. So that's really it from us. And I hope that's been a very helpful overview of the real and perceived pros and cons of an indemnity. Properly targeted and drafted, it can be extremely valuable. But if it isn't, it may not give you anything more really than a simple breach of contract claim. So that's it from us for today. You'll also find some links beneath this video to some of the latest webinars from the commercial department, as well as to our Tech Spotlight webinar series. If you'd like to keep up to date with us on LinkedIn, please follow our page, Travers Smith Commercial IP and Technology, for news, views, and general updates. Thanks very much for joining us, and we hope to see you again soon.